benefit card is a huge help to thousands of Americans that are struggling financially month to month. You can use it for whatever you need. Click the button below the ad. I'm gonna leave the link down below for you guys so you guys can do it too. Just
asking the parties to ensure that all items have been served. We went above and beyond making sure that we had provided those items. We labored under the belief that we had. Again, we're not saying that we have not made mistakes and omitted items, but they were never intentional. And Your Honor, I would point the court's attention to Morrison versus the state, where the Georgia Supreme Court says it is well established that a charge of prosecutorial misconduct is a serious charge, is not to be lightly made, and having raised it, thank you, the defendant has the duty to prove it by the record or by legal authority. The defendant here has profusely alleged misconduct. He has alleged bad faith. He has alleged prejudice, but starting, Your Honor, just with bad faith, he has failed to show one instance, one shred of evidence that the state has ever in any way acted in bad faith. And I submit State's Exhibit 5 for the court's consideration, where we documented the items that were requested, and notably absent, given the defendant's claim here today, is the search warrant return for Thugger 1 that the defendant had notice of, that the state was in receipt of, that the state labored under the impression that we had provided to the defense, and that they never once asked for. They asked for Damian Garlington's account and return, but never once asked for Jeffery Williams, Your Honor.
Okay. What about the file that says do not serve?
That, Your Honor, had items in it that were inclusive of Social Security numbers on medical records that we wanted to make sure that they were not improperly given out to anyone. There was nothing in there, and in fact, we served the folder itself after we made sure that there was nothing in there that was of a nature that was not to be publicly disseminated. That is all that was. There's never been any effort. We would not even why would we even put in a folder something that we didn't need or want for them to see, and didn't know or want them to know that we were trying to redact or in some way make certain that they have the information that they're required to have. State's Exhibit 7, Your Honor, is just a thumb drive that contains all of the motions for discovery that Defendant Williams has filed with the court, all of the requests. I can pull that up for the court as well and show that not one of them includes Jeffery Williams' Instagram returns. Your Honor, the purported evidence, for instance, the folder that says do not serve yet, that the defendant cites in support of his assertion that there has been bad faith on the part of the state, is completely void of any such evidence, Your Honor. There is no, the fact that the Williams has the folder itself belies the suggestion that its contents were wrongfully withheld. He points to nothing about the folder requiring or even suggested it should have been produced any earlier than it was. The complete lack of discussion about the contents of the folder itself is telling, Your Honor, and it is unsurprising since a cursory review of the contents of the folder makes the defendant's arguments evaporate. The folder contained a previously served disposition of a federal charge to which Casey pled guilty, which was a matter of public record. It contained an APD report associated with that incident, previously served on November 8, 2022, as part of Discovery 5, and it contains 2 files comprising roughly 5 minutes of audio in which an APD detective verifies the identity of a 911 caller from the underlying incident. Your Honor, when a defendant alleges a factually specific claim of prosecutorial misconduct and bad faith, he must show actual misconduct. And the defendant here has utterly failed to do so. His claims ignore the record, and they are based on rank speculation. He's alleged hypothetical misconduct and has not even substantiated that. Your Honor, the allegations of bad faith that the defendant has made are coextensive with his claims of prosecutorial misconduct. He has failed to supply this court with a single instance in which a court has made a finding of bad faith under circumstances like these here. And in fact, the state has operated under best of faith, as we have discussed in our response to the defendant's motion for emergency relief by the court.
All right, two things. You still haven't shown me the file from that file. Is that the file that were you able to load it? How many pictures does it have in, or pieces of it?
Your Honor, that file has, I think that there are 6 maybe PDFs, and it is not the case that there is a picture on every page with a blue line. There are pictures. I can give to the court a copy of it and let the court review it. But again, this is the exact file that is referenced in the document that I have now labeled State's Exhibit 2, which is a 79-page report wherein we informed the defendant that we, in fact, received the returns. We mistakenly thought that we had served it. When we realized that we had not, we put it and everything else that we thought we had not served in Discovery 13. We put things that they asked for, and we put things that they did not ask for that we just could not find evidence of having already served. Your Honor, to suggest that there is bad faith because we made the effort to serve it, it completely ignores the fact that the defendant...
I got it. Let me ask you this last series of questions in regards to the witness list. Why did the witness list climb why has it been climbing exponentially in terms of the number of people? You have 739 in your witness list, and it's grown,
From 658, I believe, Your Honor.
632 to that would have been 8 September to what it is right now.
Your Honor,
and if you think about it, I mean, the first witness list had 36 people on it, and okay, so I could see there being a development or a scrub of witnesses over the course of time.
And Your Honor, that is as a result of also new prosecutors on the case, different eyes looking at the case, and wanting to make sure that we have provided not just the witness list, but we acted in good faith to provide as much information as we could. And Your Honor, we did not hold anything back with any of these witnesses' names in them. The discovery containing the names were provided, Your Honor, and to the extent that we have gone as far as we have, they have now had the witness list for 2 months at least, Your Honor. Opening statements were far away from 10 days at the time that we provided the most recent witness list. That witness list is just the result of not bad faith, Judge.
But to their point, okay, you got, cases indicted in May. It was re-indicted when, in August? Or was it later than that? I'm sorry. I don't know when it was re-indicted.
It was re-indicted. That is correct. I don't have the exact re-indictment date, but it in fact was re-indicted. We'll get that for the court. Okay, so it's
re-indicted. But here's the thing. Then we started our commenced trial. December we had motions. December of 2022 we had motions. And we actually started, I want to say, the 4th of January of 2023 with actually joining issue and going ahead and selecting our jury, being in the process to select our jury. So, to the defendant's point, if the witness is supposed to be served, in 10 days or before arraignment, we've been kind of working consistently since January of this year, and it ain't like, I'm sorry, I'm using the vernacular. It's not like you got 10 witnesses or 20 witnesses or maybe even 40 or 50 witnesses. And you've got several hundred witnesses that arguably Mr. Steele and all the other people that are in this case need to go ahead and vet, because any defense attorney worth their salt is going to talk to everybody, or going to at least attempt to reach everybody who's on that witness list. So if the target keeps moving, what do you say about that? I mean, because it's grown from less than 50 to over 700.
I'm saying that shows our good faith, the fact that we are trying to provide that list, the fact that we are trying to provide them, pull out of the discovery and provide to them an actual list with all of the information about the witnesses that we can gather, along with the counts and acts with which they are associated. That is a sign of good faith, not bad faith. And we have not argued on a technicality. All of the motions to suppress filed long after indictment that we have now addressed on a substantive basis that Defendant Williams has filed. That's further good faith on the part of the state, Your Honor. The defendant now is trying, I guess, to assert that, somehow his designs on keeping out information that he feels isn't good for himself is amounting to bad faith on the part of the state when he cannot point to any action but good faith action on the part of the state. Us providing those witnesses, more signs of our good faith, Your Honor. There is no bad faith, and it is necessary, Your Honor, to find bad faith, ill will, intended bad faith, and prejudice in order for the court, for courts to sanction the extreme remedy of excluding evidence or excluding witnesses. There are a number of ways that if the defendant wants more time to look over his Instagram pages that we provided notice of back in August of 2022, then he can have that time or request that time. An administrative day or recess for him to do that does not take away his rights under his speedy trial demand, but to say that somehow the state has acted in bad faith when there's been nothing but a showing of good faith is simply misrepresenting reality, Your Honor.
Well, I have some concerns. I really do, Ms. Lowe, in terms of the number of witnesses and that have continued to grow. So my concern is that they need to be able to interview and to talk to these witnesses. So,
and Your Honor, that's why we've given them the phone numbers, the addresses. We, of course, cannot force anyone to talk with anyone. And to the extent that the smaller portion of the witness list is lay witnesses, which one might arguably have a problem finding or dealing with, the vast majority of them, the larger chunk of them, are professional witnesses.
Okay, but you told me that you're going to need all of these 737 in terms of witnesses to put on your case, and I told I'm not you, but I'm kind of asking you again. What is the more realistic universe of witnesses that you think you're going to call in this case? Is it 300, 400? I mean, I'm not holding you to that, but I mean, we got 6 defendants left, so it's kind of like, I know you got to put on your case, but...
And I can assure the court that we are culling those witnesses. We are going through and we are paring down that list. And we can probably have a list of a pared down, if you will, sort of rendition of it for the court on the 20th, if the court permits us to present that to the court. And I understand the court's concerns as well, because the court wants to present as smooth and as fair a trial as possible for all parties.
I do, but the other thing is, if I'm, these are real numbers, and anybody who's tried a case before understands the legwork that goes into being prepared. And even if I don't believe that you all were doing this in bad faith or you had the intent to do it, it doesn't still sit wrong with me from a constitutional standpoint in terms of just being able to be prepared. Mr. Steele's other constitutional issues of, he's got to be prepared, he's got to do his job, and doing your job means you got to go ahead and make sure I've interviewed all the witnesses that potentially are going to be called in this case, or to account for them.
Your Honor, we don't disagree with that, but we're just asking that the court not invoke the extreme remedy of excluding them. We're asking that the court fashion a remedy such as allowing additional time for the interviewing of witnesses. We have asked Mr. Steele and the other defendants if they would provide to the state people that they are not able to reach. We have not received anything from anyone since we have given the last list of witnesses from anyone saying that they have not been able to reach someone on the list.
Here's what I'm going to do. Okay, here's what I'm going to do in this case. Y'all could, have a seat. Like I said earlier, the court's had an opportunity to take a look at the defendant's motion for remedies based upon, or the motion to strike, motion for remedies, state's response, and Williams' motions in limine from 26 through 32. And as it pertains to other persons as affected on this indictment, the court's also considered, for the purposes of ruling, states 1 through 7, defense 1 through 4, and court 1, as well as the court's historical reflection on the trial of this case since it was indicted and re-indicted in those sessions of court. I do understand, Mr. Steele in particular, that this particular discovery has not come out in the method and manner that it might have been a smoother way to kind of let it go, to proceed, I should say. I do find that looking at Muse and the other trilogy of cases that you have cited for the court's edification, that under OCJ 1716.3, a copy of the indictment and accusation list of witnesses furnished. I'm also considered 17-16-4, which is disclosure of evidence by the prosecution and the defendants. Prosecuting attorney shall no later than 10 days prior to trial, or at such time as the court orders, disclose to the defendant, make available for inspection, copying, and photographing any relevant written or recorded statements by the defendant or copies thereof within the possession, custody, and control of the state or prosecution, any portion of any written record containing the substance of any relevant oral statement made by the defendant, whether before or after arrest, in response to interrogation by any person then known to the defendant to be law enforcement or member of the prosecuting attorney's staff. Then 2 also says you should, the state shall no later than 10 days prior to trial, or otherwise ordered by the court, furnish the defendant a copy of the defendant's Georgia Crime Information Center of Criminal History. And then 17-16-4 also talks about books, papers, and other tangible objects that are in custody, the possession, custody, and control of the state or the prosecution are intended for use by the prosecuting attorney as evidence in the prosecution's case in chief or rebuttal at the time at the trial of any violation of Part 2, Article 3, Chapter 12, Title 16. Such evidence shall be made 10 days prior to trial. And it basically just covers in 17-16-4 the requirements of disclosure of evidence. And also, I've also considered 17-16-8, which is the list of names and information concerning witnesses and about the state's requirement that no later than 10 days before trial, the defendant's attorney, then 10 days after compliance with the prosecuting attorney, but no later than 5 days prior to trial, shall furnish to the opposing counsel as an officer of the court in confidence the names and addresses, current locations, dates of birth, telephone numbers of that party's witnesses, unless for good cause the judge allows an exception to this requirement, in which the event counsel shall be afforded an opportunity to interview such witnesses prior to the witnesses being called to testify. And then 17-16-6 says that it gives the court what to do in terms of failure to comply with discovery requirements. And as with many of the cases, to include, the court has considered to include Muse, which has been cited earlier, at 316 Georgia 639. If at any time during the course of proceedings brought to the attention of the court, the state has failed to comply with the requirements of this article, the court may order the state to permit discovery or inspection, interview of a person, grant a continuance, or upon showing a prejudice in bad faith, prohibit the state from introducing the evidence not disclosed or presenting the witnesses not disclosed, or may enter such order, other orders it deems just under the circumstances. And then it gives a reciprocal issue if the defendant doesn't disclose or fails to comply with the requirements of this article. The defense has it, so it's the same as being reciprocal discovery. The responsibilities are the same. I know that the statute 17-16-8 says 10 days before trial. I know we've commenced trial, and we commenced trial in January, but we have had a long and very arduous jury selection process, and we actually, even though we've commenced trial, we joined issue back in January the 4th of this year, we still have, the jury will then be asked to hear this matter. So ordinarily, while I'm reading what the requirement of 17-16-8 and the other statutes read together comply with, there is a continuing requirement for those particular statutes to continue to be adhered to. I have some concerns about how the discovery has been meted out in this case. That bothers me because, you know, being an advocate, you do need to get ready for trial, but I don't. And looking at the case law, and looking at 17-16-8, those requirements are set forth to prevent a defendant from being surprised at trial by a witness or to include evidence that defendants has not had an opportunity to review or interview. So I'm supposed to look at exclusion, continuance, prohibition of the evidence of both bad faith and prejudice have been found. I don't believe that the state has acted in bad faith and prejudice. I believe that you all have been sloppy, and I think your presentation could have been a whole lot better in terms of the evidence that you have given the defense in a way and manner and method, that troubles me, that concerns me. But one of the things that also concerns me is I want to make sure that the playing field is level. And I can see how the defendants would be concerned about the representations of your former colleagues about what was done or what was not done in this particular case and what I heard. So to the extent that I'm going to fashion a remedy to permit the defense to have and the state to have the fairest trial in this particular circumstance, I am going to go ahead at this point in time and require the state by Monday the 20th to submit a pared down list of witnesses for all parties' consideration. The next thing I'm going to have done, Mr. Steele, is then I'll compare that you can compare that to the witnesses you've actually had an opportunity to interview. And if you've not interviewed those witnesses, I'll provide you the opportunity to interview those witnesses. You're probably not going to like when we probably are going to do that, because it's probably going to be the time period between we're going to probably be in trial for about 3 weeks, and when we recess, I'll order the state provide those witnesses for you and your colleagues to interview. So I will go ahead. So that's why I need to know what witnesses you're going to call, because I need to know the universal witnesses. So I'll give you the opportunity to interview them in person or via Zoom or whatever else. We'll work out something. The other thing I'm going to also require them to do for the lay witnesses that they wish to call is that they're going to run all their criminal histories if they haven't been run already. Because that is something that at this point in time, there is no way that the defendants can go ahead and avail themselves of the statutory procedure that's set forth. So that's the other fashion that the court's going to make sure that is adhered to. I'm only going to order for lay witnesses unless you tell me that there is a professional witness for good cause that I need to run, or I need to require that be run. But for any lay witness going to testify, it is my expectation that the state will provide that. Your
Honor?
Yes, ma'am.
As it relates to the witnesses, as I had spoken with the court before, we did speak with the GBI and the Georgia Crime Information Center, and they told us back when we first brought this issue up that the defendant could have had his GCICs in 2 days, given the time that they had then, that the state is literally not just not not that we don't have to, we literally are not allowed to. I received that from the counsel. Mr. Steele stated he knew him personally, so I reached out to him personally, to the legal counsel for the Georgia Bureau of Investigation, and one of the requirements of the state maintaining its certification is that we not do exactly that. And what they told me is that all that the defendant has to do is ask the court, and the court issues an order, and they get those witnesses in 2 days from the Georgia.
However it happens, I don't mind how we do it.
Okay.
But I want it to happen. So, Mr. Steele and Ms. Love, if you all want to do an order for my signature, I will go ahead and get that done. But I need to know the universal lay witnesses that you all want to, because there may be some you just don't want to have GCICs run for. I mean, I'm not saying you should. I'll order all of them, but if there are witnesses that really don't need to, there's no reason to run their criminal history, I would just say you exercise on the side of caution. But I will prepare an order such that they can get those criminal histories run.
And Your Honor, they said at the time I told them the number of witnesses, and they still told me that day, that number of days.
How many days?
They said that at the time 2 days.
That'll work. I mean, that may work. That may work if we do it now. That shouldn't be an issue. But I want to take that up on Monday, because I want to make sure that we're dealing with that particular universe of witnesses. And
And I'm finding that email so that I can forward it to the court and to counsel for each of the defendants regarding how to do it.
I want you all to think about and or be prepared on Monday to go ahead and write and prepare. Just have the court sign that order. But I at least would like to know by Monday how many witnesses you are planning on calling. I think that would be helpful, because if it's not this many, I mean, you can, just like much akin in civil cases, you may have, hundreds of witnesses that might be subject to call, but there's the may call list, there's the will call list, and then there's everybody else, the kitchen sink list. All right, so, I mean, if you definitely know you're going to call these people, then, we're going to call these people. Okay. If you're going to call, but subject to other things. I mean, I understand that you may have to call other people depending upon the circumstances that develop, but I just can't believe that you're going to be calling 737 witnesses.
Okay, we can work with that. Thank you.
At this point in time, it's just that the reason I'm doing that, Ms. Lowe, is primarily because I share Mr. Steele's concern of constitutional issues in terms of being able to represent his client and the other similarly accused person. So while I don't find that you committed bad faith or intent, I think that the disclosure and the way that the witness list is kind of developed, definitely I have concerns about it. And the way that I've resolved those concerns is to make sure that they're not surprised by anybody that you're going to call, and that they get everything that they should have gotten at a minimum. Mr. Steele, anything else?
No, thank you, sir.
All right. Sir, if you would prepare a suitable order for my signature with those two things, or three things I should say. And folks, to the extent that you all can get this done, I really don't want to have any other surprises with stuff that kind of comes up in terms of things that have not been disclosed. I understand this, I really do, but we are very close to going to trial in terms of summoning our jury, starting on the 27th. So we really need to go ahead and bring everything kind of to a close, and there should be no surprises at this point in time.
Yes, Your Honor.
All right. Mr. Steele, if you'll prepare an order, like I said, by the 20th. I think I've given that date for everybody else. So for my consideration, send that to Ms. Love, please, and her colleagues. We'll go ahead and do that. Okay. All right, you're welcome. All right. Mr. Helsky, or what's your pleasure in regards to the constitutionality of the gun statute? I hope that you've had an opportunity to take a look at Massey. That's why the court was kind of concerned about that.
Understood. In
terms of just being able to perfect the record, because it seems like no matter what kind of analysis, constitutional or otherwise, that the court makes, they still need to have, that was not done.
At that point.
At that point. So this court doesn't kind of want to make that same mistake and wants to go ahead and at least, that's why Mr. Harvey was very, I think, thoughtful in putting that together in terms of just you know, the evidence that the court would be able to sift through for themselves to determine whether or not that framework is something that they can consider as being
absolutely
being the determination of whether or not it's a citizen, the persons are citizens for purposes of then application to particularized statutes.
And to that point, Your Honor, the state agrees, and I appreciate Mr. Harvey's submission. We, as stated yesterday, we believe that we don't get to the point where the state has a burden, but in the interest of caution, I have prepared some exhibits that I've allowed my counsel to review, and I have an index that the court can view as I'm going to run through them and ask them to be edited.
I'll take the index, please, sir.
Yes, sir. If I may approach.
You may approach.
And these are all authorities that were cited in the September 19 brief, so there's no surprises here. These are just actual exhibits of those authorities. So, and with the Honorable Court's permission, I'm just going to go through and list them and say where they are in the brief, and then I'll ask to admit them all in toto, and not individually, just to save time. So just to get going here, Exhibit A is going to be Surefoot LC v. Surefoot Corp. 531 Federal 3rd, 1236. The pin site in the brief is 1243. It's a 10th Circuit case, 2008. That's at State's response at page 3, footnote 1. B is it's a law review article by Carlton F.W. Larson, 4 exceptions in search of a theory, District of Columbia versus Heller, and Judicial Ipsi Dixit. That's 60 Hastings Law Journal, 1371, pin site 1372. That's also at footnote 1, page 3 of the brief. Exhibit C is going to be out of the book Firearms in American History at 1 by Charles Winthrop Sawyer. That's a 1910 publication. That's at State's brief at 4. Exhibit D is going to be Poe v. Ullman. That's 367 United States 497. Pin site in the brief 542. That's also on page 4. E is going to be Ancient Laws and Institutes of England at page 3, Benjamin Thorpe, that's 1840 edition. That's going to be also at page 4. F, this is going to be from the Journals of the Continental Congress, published in 1776, and that's at page 205. It's a 1906 publication, and it was originally printed in the Pennsylvania Gazette on March 20, 1776. That's State's brief, page 7 and 8. G is going to be a Maryland Act, Acts of Maryland 14, at year 1776. It's cited in the brief as 1776 Mass Laws 479, Chapter 21. It's at page 8. H is going to be Statutes at Large of Pennsylvania from 1682 to 1801 at pages 559 and 560. It's a 1902 publication, also at page 8, State's brief. I is going to be the State Records of North Carolina at 89. That's a 1905 publication. That's also at page 8. J is going to be a May 5, 1777 Act, and it's included in Henning's Statutes at Large at page 281 and 82. Cited in the brief as 9 William Walter Henning. The Statutes at Large being a collection of all the laws of Virginia at 282. It's an 1821 edition, and that's cited at states 8. K is going to be 1779 Pennsylvania Laws 193, an act for disarming persons who shall not have given attestations of allegiance and fidelity to the state at sections 4 and 5. It's cited in the brief at page 8. 7 is a scholarly article, historical scholarship. The right to arms, does the Constitution or the predilection of judges reign? 36 Oklahoma Law Review 65 at 96. Robert Dolet wrote that, and that's at State's Brief, page 9. M is going to be another historical authority by Don B. Cates. Handgun prohibition and the original meaning of the Second Amendment. That's at 82 Michigan Law Review 203 at page 266. It's a 1983 article. That's at State's Brief, page 9. N is going to be also by Don Cates, a modern historiography of the Second Amendment. That's at 56 UCLA Law Review at 1211 at 1231 Penn site. That's note 100. It's a 2009 article. State's Brief at 9. O, Stephen P. Halbrook, to keep and bear their private arms. The adoption of the Second Amendment, that is from 1787 to 1791, and it's at 33. It's cited in the brief variously as 3 different items. One was Bernard Schwartz, A Bill of Rights, a documentary history. Another one was that it was a Boston Independent Chronicle newspaper article. And then also we cited as Stephen Halbrook, That Every Man Be Armed, 86, the revised edition 2013. But again, that's at page 9 and 10 of the State's Brief, and that's Exhibit O. Exhibit P is going to be the debates in the several state conventions on the adoption of the federal Constitution, 326. That's a second edition, 1836 publication by Jonathan Elliott. That's at State's Brief, page 10. Q is the address and reasons of dissent of the minority of the Convention of Pennsylvania to their constituents at unnumbered page 8 of 29. We cite this in the brief at pages 10 and 11. R is the case of Binderup v. Attorney General of the United States of America, 836, Federal 3rd, 336, 368 Penn site. That's a Third Circuit 2016 case, and that's at State's Brief at 11. S is an 1804 Missouri Law, 90, that's at page 11. T is also an 1804 but Indiana Act at 108, also page 11. U is 1806 Maryland Laws 44, that's also at page 11. V is 1851 Kentucky Acts 296, also at page 11. W is 1860 to 1861 North Carolina Sessions Laws at 68, also at page 11. And I think X is 1863 Delaware Laws 332, also at page 11. Those I include just so that I'm not accused of cherry picking history. Those are just some laws that were in existence at that time, Your Honor. They're not particularly helpful to my argument, but they're included nonetheless as exhibits. Y, 1878 New Hampshire Laws 170, chapter 38 at section 2. We cite this in our brief at page 11. Z, and it goes to WW, just so there's an end in sight here.
Yes, sir.
Yes, sir. Z is a digest of the statute law of the state of Pennsylvania from the year 1700 to 1894. That's at 541. That's an 1894 publication, 12th edition. We cite that in the State's Brief at 11 and 12. AA, Annotated Statutes of Wisconsin, containing the general law in force October 1, 1889 at 940, 1889 publication. We cited at page 12. Double B, State v. Hogan, 63 Ohio State, 202, Penn site 218, 219. That's a 1900 case. That's at page 12. Double C, General Statutes of the State of Kansas at 353 and 1897 digest. That's at page 12. Double D, 1883 Kansas Sessions Laws 159, section 1, also page 12. Double E, 1923 New Hampshire Laws 138 at section 3, that's at page 13. Double F, 1923 North Dakota Laws 380, chapter 266 at section 5, page 13 of the brief. Double G, 1923 California Laws 696, chapter 339 at section 2, also at page 13. Double H, 1925 Nevada Laws 54 at Chapter 47, Section 2, also at page 13. Double I, 1931 California Laws 2316 at Chapter 1098 at Section 2, also at page 13. Double J, 1933 Oregon Laws 488, page 13. Double K, 1931 Pennsylvania Laws at 497, 498, Chapter 158, Sections 1 through 4, State's Brief, page 13. Double J, 1933 Oregon Laws 488, page 13, State's Brief. Double K, 1931 Pennsylvania Laws 497. Am I repeating myself? I'm going to go from KK. I'm probably repeating myself. These are all bleeding together, but 1931 Pennsylvania Laws 497, 498, Chapter 158, Sections 1 through 4. I feel like I already said that. Double L, 1927 Rhode Island Public Laws 256 at Section 1, page 13, State's Brief. Double M, Don Cates, the Second Amendment, a Dialogue, Law and Contemporary Problems, 143, and that's at Penn Site 146. It's a 1986 scholarly review, or scholarly article, that's page 14 of the State's Brief. Double N, A Critical Guide to the Second Amendment, that's by Glenn Reynolds from 1995, and it's 62 Tennessee Law Review 461 at 480, also at State's Brief, page 14. Double O,
you can send money direct to bank accounts with Western Union faster than I can talk. Faster than I can talk.
Scholarship, that's 29 North Kentucky Law Review 657 at 679, that's a 2002 article, State's Brief at 14. Double P, The Second Amendment, Structure, History, and Constitutional Change by David Yaskey, 99 Michigan Law Review 588, Penn Site 626, 627, a 2000 historical article, page 14, State's Brief. Double Q, Saul Cornell again, this time with Nathan Dedino. This one's called A Well-Regulated Right, The Early American Origins of Gun Control, 2004. It's 73 Fordham Law Review 487 at 491 to 492, State's Brief, page 14, page 15. Almost there. RR, United States versus Rennie, 583 Federal 3rd, 8, Penn Site 15. It's a First Circuit 2009 case, State's Brief at 15. Double S, United States versus McCain, 10th Circuit 2009 case, 573 Federal 3rd, 1037 at Penn Site 1047, State's Brief at 15. Double T, United States versus Anderson, 559 Federal 3rd, 348, Penn Site 352 at Note 6. It's a 5th Circuit 2009 decision, State's Brief at 15. W, 2 U's, United States v. Yancey, 621 Federal 3rd, 681, Penn Site 684 to 685, 7th Circuit 2010, that's at State's Brief at 15. Double V, U.S. v. Carpio Leon, 701 Federal 3rd, 974 at 979 and 980, 4th Circuit 2012 decision, that's at State's Brief, page 15. And finally, WW, U.S. v. Freeman. This is a Northern District of Illinois case decided June 1st, 2023. That's 23 CR 158 at Penn Site 4, State's Brief at 15. I'm sure over my colleague's objection, I would move to admit State's Exhibits A through WW.
All right, Mr. Harvey?
Thank you, Judge. I'm going to go through them and tell you which ones I have an objection to and why.
All right, sir.
Shall I yield the floor?
I hope you do. Can you grab that?
No problem.
We have just heard a long list of what the state has tendered to the court in support of what they believe to be, now believe to be their burden, which I believe I have always said it was their burden. And that burden is enlightened by the court in Bruin as follows. The scope, and this is what I argued yesterday, the scope of the protection applicable to the federal government and states is pegged to the public understanding of the right when the Bill of Rights was adopted in 1791. The Bruin Court specifies, and I will give you the exact quotes when I get to the particular parts of the proffer, Judge, with regard to pre-1791 authority and post-1791 authority. The first item on the state's response, thank you, is a citation to a case in 2008 before the Supreme Court said that the Second Amendment confers an individual right on people to keep and bear arms. That was in Heller, which is a 2011 Supreme Court case. So for whatever relevance that case may have, I don't think it has any relevance to pre-Heller construing the Second Amendment as a personal right. I'm drinking smart water. I'm getting smarter as I go along. I hope. That's for the record. That's for the record. Yeah. Second, it appears to me that that is a 2009 law review journal. You can take a law review journal for whatever value it might have, but it certainly isn't a specific historical analog to either of the Georgia statutes. C, Firearms in American History, 1910. I wasn't pointed to any particular portion of that, and I don't know particularly what relevance that may have. Same thing with D, Poe versus Ullman, 367 U.S. 497, 1961. With regard to the pre-Heller relevance, I don't particularly see that. So I'm objecting so far to the first four, A, B, C, D. Now, we get to E. And Exhibit E is denominated on the list as Ancient Laws and Institutes of England. That's a one-page exhibit. On that one-page exhibit, I see, without any pages before, without any pages afterwards, a quote that says, "If a man furnish weapons to another where there is strife, though no evil be done, let him make," I don't know, let him make bot with, and that's not bots, but bot, with a number of shillings. So we've got an undated law, apparently of England. I don't even know where it comes from. I don't know what date. I don't know what anything with regard to that. And it certainly is not a prohibition on the ownership of weapons. The Supreme Court said, and I said I'd go with each one of these, as far as English history is concerned, the court in Bruin said, English history is ambiguous at best, and the Bruin court saw, quote, little reason to think that the framers would have thought it applicable to the New World, unquote. That's Bruin at 2139. So I object to E. The journals of the Continental Congress, you know, all this stuff sounds great, but when you read it, it doesn't It simply is inapplicable. I guess I'm on F. Journals of the Constitutional Congress, 1776 at 205. Well, what they said was that it be recommended to the several assemblies, conventions, and councils or committees of safety in the United Colonies. And Georgia had a committee of safety. This was a recommendation that they were going to give to the committees of safety to immediately cause all persons to be disarmed within their respective colonies who are notoriously disaffected to the cause of America, or who have not associated and shall refuse to associate to defend by arms these united colonies against the hostile attempts of the British. So that's an oath. That's a recommendation to prohibit those people who don't support and are enemies of the United States of America to disarm those people. Certainly not a historical analogy to our statute, so I would object to F as well. G. Now we're getting into the acts of 1776 in Massachusetts. 1776 happens to be, if I recall, Paul Revere's ride, right in the middle of the American Revolution. And what that says is an act for the executing in the colony of Massachusetts Bay in New England, recommending the disarming of such persons as are notoriously disaffected to the cause of America, or who refuse to associate to defend by arms the United American Colonies. Same thing as in F. In other words, it's those who refuse to take an oath of loyalty to the United States. Has nothing to do with the disenfranchisement of felons. Exhibit H, the statutes at large of Pennsylvania from 1682 to 1801, same thing. Recommending upon the Honorable Continental Congress recommended to us that we cause all persons to be disarmed who are notoriously disaffected to the cause of America, who have not associated and refused to associate, etc. In other words, exactly the same thing, disarming those who refuse to take the oath to protect America in the Revolutionary War. So the next is I, the state records of North Carolina from 1905. That's a 35-page document. The print is smaller than my bank account. I have absolutely no idea where in the 35 pages of supremely small print there is anything related to disarming any individuals. And I haven't been pointed to anything in that particular exhibit that shows anything with regard to disarming felons. So I'm objecting to that. J, again, May 1777, another oath. who will not bear the not give oath to the allegiance to same and for other purposes. All freeborn male inhabitants above the age of 16 years, except imported servants during the time of their service, shall, on or before the 10th of October, subscribe the following oath. And if they don't take the oath, they get disarmed. So that's another oath session or statute. K, same thing, another oath statute. So far we haven't had a single, not a single. We're going to disarm felons. We're going to disarm permanently those who may be convicted of felons. So far, absolutely nothing. I see nothing in any of those. So that's J and K. L, that was a law review article from 1983. M is a law review article from 1983. N is a law review article from 2009. O is a law review article, it looks to me, from 2013. So I object to L, M, N, and you can consider whatever law review articles you want to consider, but they certainly aren't historical analogs, and I've gotten nothing so far by way of the record of any particular statutes from anywhere in the United States. P is the debates of the several state conventions on the adoption of the federal Constitution. Well, that's all good and well. I don't know what that has to do with anything, so I would object to that. Q. I'm sorry?
Could you clarify what your objection is?
Yes, my objection is that it is not an historical statute. It is not a statute anywhere. It is also something that may or may not have been adopted by any particular state, and certainly not been shown to be adopted in the state of Georgia. I am not abandoning a dual track. I've seen nothing particularly related to Georgia, and I see nothing in this particular article that may or may not. And I haven't had a chance to read all these articles because I just got these today at 12 o'clock. Over my objection.
They were cited in the state's brief file.
That's great, over my objection. You didn't tender them yesterday. We had a hearing yesterday. They weren't tendered yesterday. I object to them being tendered today. R is a pre-Bruin opinion, quoting another pre-Bruin opinion.
To clarify, is there an objection to Q?
Yes, there's an objection to Q, there's an objection to R. Now, let's get to S.
What was the objection to Q? I'm not clear.
Well, if you're not clear, I'm sorry. So I'm at S. We kind of blew through S. S is an 1804 Mississippi law. And that law says, no slave shall keep or carry any gun, powder, shot, club, or other weapon whatsoever, offensive or defensive. And I can tell you what's offensive to me is that the state is tendering this statute as a historical analog to the prohibition against felon disenfranchisement in 2023. And for the record, the 14th Amendment, I think, renders explicitly racist laws in slave codes irrelevant to the Bruin analysis. Bruin does not even consider the many explicitly racist laws of the 18th and 19th centuries. A ban on restricted groups cannot be an historical tradition. Let's go with, so that is beyond objectionable. Let's go with T. 1804, Indiana Acts, a law entitled A Law Respecting Slaves, be it further enacted that no slave or mulatto whatsoever shall keep or carry any gun, powder, shot, club, or other weapon whatsoever, offensive or defensive. Again, if the state thinks they're going to rely on that as a historical analog to the current 1980 Georgia felon disenfranchisement law, then I think it's barred by the 14th Amendment. I think it's barred by common decency. Let's go to you. 1806 in Maryland. And here's what the title of that statute in 1804 from Maryland that the state is tendering to the court. An act to restrain the evil practices arising from Negroes keeping dogs and to prohibit them from carrying guns or offensive weapons. That's what the state is tendering to you. (1851) in Kentucky. Let me just say this. 1851 is 51 in 8. It's 58 years after 1791. The court in Bruin specifically said if a law was adopted long after the founding, it cannot be afforded much weight. Heller said that at 554 U.S. at 634, 635. Bruin at 142 Supreme Court at 2316 cautioned against, quote, giving post-enactment history more weight than it can rightly bear. Even if it's relevant, it's adopted too long after 1791, which is the relevant date. So, Exhibit V, 1851 Kentucky Act of dealing with slaves and suffering them to go at large. If any Negro shall keep or carry a gun or other deadly weapon, powder, or shot, the same may be seized by any free white person. I object to that. And that was, what, V? W. 1860, 1861. North Carolina sessions, and again, I'm relying on Bruins and Heller specifically saying if it's too far past the founding, it's to be given little weight. But again, the state's tendering it to you to meet their, quote, burden. 1861, North Carolina Session Law 88, relating to free Negroes having arms. If any free Negro shall wear or carry about his person or keep in his house any shotgun, musket, rifle, pistol, sword, etc., he shall be guilty of a misdemeanor, and upon conviction fine not less than $50. That can't be a historical analog to a felon disenfranchisement law. Next, 1863 Delaware law. This is Exhibit X. And by the way, I'm objecting, obviously, to all of these. 1863 Delaware laws enact in relation to free Negroes and mulattoes that free Negroes and free mulattoes are prohibited from owning or having in their possession a gun, pistol, sword, etc., etc. So here's the state's proffer of laws that are historical analogs. The next is 1863. That is, well, I'm sorry. Maybe I missed something. Did I miss X? 1863 Delaware law.
No, and if I may,
Yes.
Again with S through X, I just put those in to avoid the accusation that I'm cherry picking. I'm presenting the history, warts and all.
Okay, well, there are plenty of warts. There are more warts than anything else. Y was 1878 New Hampshire law, Exhibit Y. That's 87 years after the 1791 adoption of the Second Amendment, which prohibits a tramp from having a weapon. Any person going about from place to place begging and asking or subsisting upon charity shall be taken and deemed to be a tramp and shall be punished by imprisonment at hard labor for not more than 15 months. And a tramp with a gun gets up to 2 years in jail, but doesn't get disenfranchised. That's why. Z is in 1879, which is 88 years after 1791, and that's the same statute as Y. It is a statute that is an 1879 statute saying the exact same kind of thing, that it's a misdemeanor to be a tramp with a gun, but no disenfranchisement and, frankly, no seizure of the gun. And let me see.
But, Mr. Harvey, if I may, in Bruin, doesn't it say that...
Hey, look, I'm not answering your questions.
Oh, wait.
Good. You shouldn't have an opportunity to go again.
Mr. Harvey, we're not going to have any of that. You can look at me all cockeyed if you want, but we're not going to have that.
Well, I didn't start it.
But you were starting to finish it, and that's what
I was.
That's what being professional is all about.
All right, that's fine. I won't finish it. I'll finish it with the continuing reference to their proffer.
All right.
Let's see, AA. Annotated statutes of Wisconsin containing a general law being enforced in 1889, which is obviously well after 1791. And that statute is again a vagrant or tramp statute, and the penalty for a vagrant or a tramp or someone who is drunk and has a gun is imprisonment in the county jail at hard labor not exceeding 3 months, or by imprisonment in such jail in solitary confinement for not exceeding 10 days. So I object to that one. State versus Hogan, a 1900 case from Ohio. I must have missed it, but I didn't see State, the Georgia case that we all rely on and that the Supreme Court quoted with approval in Heller. That's Nunn versus the State. I also didn't see and haven't seen yet, and we're up to the 1900s now, anything that the state proffered, from the state of Georgia in particular, that any state statute that disenfranchised someone who got convicted of a felony. So I object to the relevance of BB, State versus Hogan. CC is an 1897 statute from Kansas, and CC is an 1897, which, again, I want to say that under Bruin, once again, at 142 Supreme Court pinpoint at 2316, cautions against giving post-enactment history more weight than it can rightly bear. This is many years after the 1791 enactment, and this prohibits carrying a deadly weapon. Any person who is not engaged in any legitimate business, or any person under the influence of intoxicating drink, and any person who has ever borne arms against the government of the United States, who shall be found within the limits of Kansas, carrying a pistol, bowie knife, dirk, or other deadly weapon, shall be subject to arrest upon a charge of a misdemeanor, fined $100 or 3 months in jail, or both. Again, I object to that as being any even remotely relevant as a historical analog. DD is an 1897, well, maybe it's not 18, let's see, DD. It's another Kansas statute. I don't know why I have 1897, but I'll take the state at its date. 1883 is what they have on DD. But that prohibits any person who sells, trades, gives, loans, or otherwise furnishes a pistol to any person of notoriously unsound mind. And the penalty for that, giving anything like that to a person of notoriously unsound mind, was a misdemeanor. I don't think that qualifies, and I object to that as a historical analog. Now we're into the 1920s. We're well over 100 years past the 1791 adoption of the Second Amendment. I guess by my limited ability to add and subtract the 1923 New Hampshire laws, that's 132 years after the adoption of the Second Amendment, and it specifies in 1923, way beyond the period that Bruin says is relevant. I believe that it says that no unnaturalized foreign-born person and no person who has been convicted of a felony against the person or property of another shall own or have in his possession a pistol or revolver. God bless you. A pistol or revolver. A violation of the section shall be punished by imprisonment for not more than 2 years, and upon conviction, the pistol or revolver shall be confiscated. Now that may be the first that I've seen that the court might deem to be relevant to this inquiry. I say it's not based upon the exact wording of Bruin. However, it is, in fact, in 1923, 132 years after 1791, something that doesn't disenfranchise a felon, but what it does is, and of course, there is a difference between confiscation and future prohibition. So I will concede that may have some relevance to Your Honor, and that is EE, the 1923 New Hampshire statute. There's a 1923, again, 132 years later, FF, that is an enhancement for possessing a weapon while committing a crime when armed, and also includes unnaturalized foreign-born persons convicted of a felony. It doesn't disenfranchise or allow for confiscation of a felony, so of the gun, so I'm objecting to FF. GG is the 1923 California law, again, 132 years after 1791. And again, it's a sentencing enhancement for someone committing a crime when armed, and it provides for confiscation of the arm, but not prohibition from future owning an arm. And again, it's not a felon disenfranchisement law. Number, let's see, HH. HH is a prohibition, 1925, 134 years after 1791. It prohibits felons from possessing a pistol, a revolver, or a firearm capable of being concealed, but doesn't prohibit the possession of long guns or guns. There is not a prohibition on owning guns, just on certain types of firearms. So I don't think that's it's certainly not a historical analog. IIJJKK, I think both of those three do prohibit felons in possession. You can take those for what the court might think they are worth, but they're 1931, 1933, and again 1931. So you can take those into consideration. Again, I think they carry zero weight under Bruin, but they're felon disenfranchisement. They're felon prohibitions on possession of weapons. There's no showing by the state that they are permanent disenfranchments as opposed to confiscations. LL, the 1927 Rhode Island public law, is not a felon in possession law, and I would object to it. A 1980, MM is a 1986 law review article. I don't see the relevance of that. I don't see the relevance of NN. I don't see the relevance of OO. I don't see the relevance of PP. I don't see the relevance of QQ, all of which were written before Heller determined for the first time that there was an individual Second Amendment right to bear arms. 88, RR, SS, TT, UU, VV, UU are all pre-Heller cases. VV is the only post-Heller case that I see cited, and that is a pre-Bruin case, almost a decade before Bruin. And there's one citation here, one little citation to a case from the Northern District of Illinois from this year. For what value that may have, the court can consider that. So those are my objections to the state's proffer. And of course, and I'm sorry, I had objected to the court allowing the proffer because yesterday, I believe, was the time that the state had to meet its burden. Again, I have seen or heard, and the state has not proffered a single, not an iota, not a scintilla of evidence regarding any felon disenfranchisement laws in the state of Georgia or any statutes or constitutional provisions from the state of Georgia. I think that's where we are. So I objected to allowing the state to put these in, although I think, frankly, it helps me. Now, they had their shot. You graciously allowed them to present this, this mass of materials, which I scrambled to look at over lunch. And again, remember, it's not my burden. So the state has had an opportunity now to put into the record whatever they wanted to. I've made my objections. I think the record is ready for Your Honor to rule without any further argument. So, Judge, that's all I have.
All right.
Your Honor, just so the record's clear, I am not Mr. Harden's argument on behalf of Mr. Still.
It'll apply to everybody unless you opt out.
One thing, one final quote. Yeah, I know. And it's a good one. This is a good one. On February 7th, 1867, Frederick Douglass gave a famous speech in which he said, "Keep no man from the ballot box, or jury box, or the cartridge box." I'm leaving that with you. I got it.
All right, anything else, Mr. Yelsey?
May I have 30 seconds?
You may.
All right. Mr. Harvey went into great detail about how all these statutes that I provided are hundreds of years at a time. Instead, what I would draw your Honor's attention to is Bruin at 2119, which says, and I'm going to quote, "Constitutional rights are enshrined with the scope they were understood to have when the people adopted them. The Second Amendment, 1791. The 14th, 1868. Historical evidence that long predates or postdates either time may not illuminate the scope of the right." Just to make that clear. Now, Mr. Harvey's also talked about how I haven't provided any Georgia statutes that prohibit felons from firearms. I don't need to. It's about whether the current Georgia statute is consistent with the nation's historical traditions, whether it's an oath, whether it's a legislature, whether it's a convention talking about what they want to have in the Bill of Rights. We're looking at the national history. I don't have to have a historical twin. I just need a historical analog. And from the briefing, I'll just reiterate, there is at least one. You go back to AD 602, and from there, it's enemies of the state, okay? And then it's violent persons, dangerous persons, and then criminals, and then you start getting into the late 19th century and into the 1900s. They start calling it, by felonies. So I think we have more than enough as far as a historical analog, and I do appreciate the court's indulgence allowing me to have some extra time to get this together, and I would move to admit these for the court's consideration. Thank you.
All right. Thank you, sir. All right, to begin with, I am going to admit over Mr. Harvey's objection, the state's index of exhibits and state's response to opposition to Cornelius Nichols, Shannon Stillwell, Monte Kendrick, and others, and to all persons as set forth in this indictment, 22 SC 183-572. The court, after hearing arguments of counsel and after considering the state's exhibits 1 through WW for consideration and submission for the record, as well as defendants 1, 2,
No, that's what Reverend had approaching and get these things to
which ones?
The A through WW.
Yes, you can give them to, in fact, you can give them to Ms.
Thank you, Your Honor.
Ms. Weaver. It's from this one. This one. This. Okay. Okay. All right. Okay. Yeah, I did. Okay. All right. And I'll make her. And I'll include the index that was submitted for my consideration as courts one for purposes of this particular motion. All right, after careful consideration and from the court's resuscitation of the issues presented, and a careful consideration of Massey versus the state of Georgia at 2020 Westlaw 6973557, as well as Kuhlman versus the state, that's KUHLMAN versus the state at 892 Southeast 2nd, 753, and taking a look at Georgia Code, or Georgia, Official Code Georgia Annotated 16-11-31 and 16-11-33. This court rules that it is not going to declare OCGA 16-11-131 and 16-11-133 unconstitutional. I find them constitutional. I'm not going to bar or otherwise strike the prior convictions, Acts 77, 175, and 191, and current charges, counts 53 and 65 thereon. Thereupon. This ruling will apply to all those similarly situated under the indictment 22 SC 183572. Mr. Uhelski, if you will prepare a suitable order, you can guess what date I'll give you. The 20th. And you submit that or socialize that with Mr. Harvey and the others as required. And I'll take a look at it before entering it, okay? All right, sir. Say again?
Can I have an interlocutory appeal?
No, not this time, sir. Okay, Mr. Uhelski, is it you or Ms. Love or Ms. Hilton's going to handle the motions to suppress in terms of Mr. Nichols' arrest in 17, 18, and finish the motion to suppress the phone records?
Your Honor, I'll be handling the suppression of the 2017 and 2018 statements.
All right.
Anything else we be handling the cell phone.
Okay, I think we're supposed to finish, we started the cell phone records. Is that correct, sir?
Yes, Your Honor.
Or ma'am? And then we can go ahead and, so which one do you want to do? We're going to take about a 5-minute break, and then which one do you want to start off with?
We can start with the cell phone, Your Honor.
All right, so we'll come back in about 5 minutes, Mr. Harvey and Mr. Stillwell, and we'll go ahead and finish these. We'll go ahead and take the phone records first.
And Your Honor, prior to you taking a break, Ms. Westmoreland, she spoke to me earlier. The state had not read a response to the particularized motions. We're ready to move forward. We have our witnesses here. However, we never had an opportunity to respond in writing. And so I think there was some concern about the fact that we had not responded in writing to their particularized motion. They filed their motion on the 8th, which was last Wednesday. And so given that we've been in court primarily, we just have not had the option to sit down and do a written response to their particularized motion, which was filed on the 8th.
Okay, but you've been able to respond to their particularized motion?
Not.
Or do you have the witnesses to address that?
You do have it.
All right, then we'll take it from there then. Okay. All right, we'll see everybody in about 5 minutes or so. It's around 8:22.
Is that the date?
Now,
Good afternoon, Your Honor.
now, yes.
Ms. Westmoreland, on behalf of Defendant Nichols. Your Honor, we are ready to proceed on the cell phone motion. The reason why the state mentioned the 2017 and 2018 motion is because the state and defense counsel on behalf of Mr. Nichols spoke today and intended on asking the court jointly if we could hear this motion on Monday for two reasons, and you only had the chance to hear one. The reason is that late yesterday evening/night, we received new discovery on the motion to suppress, and we have not had the opportunity to review that discovery. Some of it's about the K-9, some of it's an Instagram video that started this whole investigation or investigatory stop. I think some of it's a manual, but I haven't had a chance to look through it. Additionally, while we've been in court today, we received some more discovery. The new police report or the original report or something of that nature, the whole incident report wasn't complete and the state just found out about it, was their representation, and has sent it over to us. I haven't even opened up the email. So, Your Honor, from my understanding, the government also wanted the opportunity to respond to our particularized motion. We believe their response, giving them the opportunity to respond will be fair and best. They've communicated to me that they can have that particularized response filed today, and that they would be ready to move forward on Monday, and that would give us the weekend to look over the discovery that we just received today in court and the discovery that we received last night, and I think that we would be ready to go on Monday also.
All right. What's the state's response?
Yes, Your Honor. I'll speak first to the items that were served last night. In preparation for the motion, Your Honor, as I was reviewing the police report and having conversations with the officer who, let me back up. There's two stops. So there's a 2017 stop and a 2018 stop. As relates to the 2017 stop, there's nothing new that has been submitted. The 2017 stop is a stop in which Mr. Nichols was in a car that was tinted. They stopped the vehicle under the consent to search. The vehicle was searched and guns were found. So I do not believe that there was anything additional for the 2017 stop, period. As it relates to the 2018 stop, when I met with Sergeant Ross yesterday in just preparation for the motion, in reading it, Sergeant Ross advised that the first time he saw Mr. Nichols was on an Instagram video. I had not seen anything prior to that to show Mr. Nichols in the Instagram video, so I wanted him to explain to me more what was he referencing. At that time, he explained to the state, I have the video, do you want me to send it to you? So he said yes. And immediately as he sent it to me, I watched it. It was about a 30-second video clip. I immediately sent that video clip over to defense counsel to show this 30-second video, but this is what he saw to end up doing the actual search of the vehicle. And so I needed that information, of course, to provide to the defense counsel. In addition to that, he sent me, I guess when he took the video, and this is all back in 2018, he also provided like a one-page picture of Mr. Nichols in the same clothes that he was in the video to kind of corroborate that this was the same person he was referencing. So he sent that to me as well. In the evening, later on, in 2018, so after the officers are able they bring out the canine. And so the canine has to sniff around the car. Well, in my experience of having motion suppressed in these types of cases, most defense attorneys want the canine certification. So I had to get that from that officer in order so I could serve that to make sure that defense counsel had everything that I generally know that they want in these types of cases, these types of suppression hearings. So I got all of those items. The only other item that was served, Your Honor, is the body-worn camera retention policy. So for APD, and I apologize, I didn't make a mistake. As it relates to the 2017 stop, the defense counsel had requested the body cam video. Sure, we probably brought this before the court. That video is no longer in existence. We spoke to evidence.com, we spoke to a number of different people as to why that video was no longer in existence. When I met with that witness in the 2017 case, he's very familiar with the retention policy for for APD, and he advised that APD has a 5-year retention policy as it relates to arrest body cam videos. So I wanted to provide that to the defense counsel as proof that we didn't just lose the items, but that was their retention policy. So those were the items that I served last night. This morning, Your Honor, Sergeant Ross from the 2018 case called me early this morning and said, "Hey, Ms. Hilton, I know the report you gave me last night. I don't think that's the full report." I went back, after me and him and I met, he said, I went back to my office to pull up the report, and I had the full report with my supervisor's signature. I said, "I need you to send that to me immediately." As soon as he sent that to me, I forwarded that to defense counsel. They were in court at that time, but as soon as he sent that to me, alerting me that the report I showed him last night was not the same report, I immediately sent that over so that they could have it. I received it, I think maybe at 10 o'clock this morning, probably about 10:05, it was forwarded to the defense counsel. So those are the items that were served, Your Honor. Again, this is stuff that I learned as I was prepping my witnesses for the hearings this morning. As it relates to the written response, my colleagues who were here earlier this morning, Mr. Uhelski, advised me that clearly tonight would not have been ideal because we're in court here, but they did say that we would have a response by tomorrow if the court would allow. And I think that was what the conversation was. We were ready. Our Sergeant Maldonado had literally been outside since 10 o'clock this morning when we told him to be here. Sergeant Ross is on his way. But we understand that we have not had time to do a written response. So if the court permits that, we will do a written response, but otherwise we are ready.
Your Honor, may I briefly respond?
Madam.
Is it yes? All right, Your Honor, this is, a few minutes ago or a little bit earlier this morning, you expressed concern and you having understanding for the concern and defense counsel and being worth our salt. Your Honor, we're not supposed to, any defense lawyer that is worth their salt, just read a document. You need to review it, you need to read it, you need to digest it, you need to investigate it, you need to speak with your client about it. So it's not just reading a few pieces of paper. The social media post, from my understanding, this is what started it all. We need to speak to our client about that post. We need to investigate that post. The retention manual, from my understanding, the body camera has disappeared. I don't know what the retention policy is. We want to have the opportunity to read the whole manual. I don't want to waste our time or the court's time asking 100 questions on why that body camera was not kept and what was the efforts and things of that nature. I need to see what the policy says. The tweet or the post, we need to review it. We need to investigate it. And if counsel said tomorrow in reference to written responses instead of today, I apologize. Tomorrow is okay with us if it's okay with the court. But the K-9 certificate, we want to see it. We want to review it. We want to investigate it. We want to speak to our client about it. It's not just simple as watching a 3-minute video or reading over, 30 to 100 pages. We do a little bit more than that to be worth our salt. So, Your Honor, we would jointly ask to hear this on Monday, and from my understanding, what we've received thus far, that should give us enough time to earn our salt, and we're fine with a particularized response tomorrow, and believe that it would be helpful.
You're talking about just the stops for the step in 2017, 2018?
Yes, Your Honor.
Okay. And you're prepared to go forward on the cell phone records or finish that this afternoon?
Yes, Your Honor.
How long will it take, do you think it will take to hear the motions for the 7th in regards to the stops that were in 17 and 18? Just ballpark.
Yeah, I would think about 2 hours for both of them to come out.
All right, I'll add it to Monday, the 20th, and I'll authorize you to file a response tomorrow. Make sure it's served upon all parties.
Yes, Your Honor.
And as well as the court, because I'm not an e-file party. So,
Thank you, Your Honor.
you're welcome. Yes, so, yes, ma'am, you do. Bless you. All right, Mr. Helsky, are you going to handle the rest of the cell phone issue?
I'm gonna try.
All right, okay. Just to frame the issue, we started this particular motion on August the 23rd of this year. I have admitted for my consideration as far as states 1, and I want to say that was from Officer Hogan. All right, so we can pick it up from there.
Just from my recollection, Judge, S1, is that the warrant and the affidavit?
it's the warrant and affidavit and application. Mr. Harvey, did you hear me? Okay, all right, sir. Okay, go ahead and continue, sir.
All right, so Your Honor, my recollection is that we had left off, and the main 2 points that remained were the sort of jurisdictional territorial issue, and then the magistrate court judge signing this warrant, and there being sort of a lack of a designation of that judge as a superior court judge in doing that. I believe those are the 2 issues that we were left with, but if not, I'm prepared to address the other ones. But I'll start, and I just want to, this will, I guess, be on page 4 of States 1. This is the actual affidavit that has been tendered into evidence, and I have it as page 2. It may be on page 4 of States 4, but it's where it says your affiant, Detective Al Hogan. I'm just going to remind the court of where we are with this. So Detective Al Hogan is a duly sworn post-certified Atlanta police officer and has been a sworn officer since 1987, serving with Atlanta Police since 2011. Previous experience in Fayette County Sheriff's Department, Federal Air Marshals, and the DEA Task Force. He's been assigned to homicide since January 2017, has over 1,700 hours of training over his career, to include extensive training in the prep of and execution of search warrants pertaining to criminal investigations. Prepared and participated and executed a great number of search warrants when it comes to criminal activity. So on March 14, 2022, at the 400 block of Windsor Street Southwest in Fulton County, Shamel Drinks shot and killed inside his red Nissan bearing a Texas tag. He was the sole occupant of the Nissan.
Judge, the affidavit speaks, the affidavit's in evidence. I don't know whether we need.
Yeah, I can read it. I mean, I've read it. So, is there any?
It's just that one of the, I guess, and again, I'm not sure what all allegations are still in place. So one of them was the lack of particularity. One of them was kind of the lack of certifications and stuff like that.
I'm sorry. Mr. Harvey has, in fact, filed a particularized motion to suppress the cell phone records. He's filed, in fact, 2 of them. He's filed one on the 28th of August and one on November the 13th. So if you want to gather your thoughts around that, are you recalling a witness, or what are you going to do? Just argument.
It'll be just argument this time.
Okay. All right.
So just getting to the, I guess, the important issue here. The issue raised in Division 2A of Mr. Harvey's particularized motion, he's alleging that the search warrant used to obtain his client's cell phone records was defective because it was issued by a magistrate judge.
You talking about his response from the 28th or from the?
This is the August 28th.
13th?
Yeah, this is the August 28th particularized motion to suppress.
Okay.
I'm referring to. So this is going to be, Division 2A.
Improper jurisdiction of judicial officer.
Sure. So he's saying that because a magistrate judge issued this, it's faulty. That's incorrect. OCGA 1611-66-1 does require that a search warrant for a phone such as this be issued by a judge with, competent jurisdiction. But if you look at OCGA 1510-2, which talks about magistrates, it says they're courts of general jurisdiction, and it also says in A1 that each magistrate court and each magistrate thereof shall have jurisdiction and power over the following matters. And the first thing it lists, number 1, A1, the hearing of applications for and the issuance of arrest and search warrants. And this makes very good sense, Your Honor, because when you read cases about probable cause determinations, whether for arrest, whether for search warrants, the law, I mean, Your Honor remembers Moon, all these cases we've been talking about for the past few months, they always talk about probable cause, and they always talk about the magistrate's determination, don't they? Almost every single time. So to say that a magistrate doesn't have power to issue search warrants because this is a felony, murder, right? It's a little bit of a stretch because magistrates have power to determine probable cause as to any level of offense, whether it's murder. They can do a probable cause hearing, preliminary hearing. They're not going to have jurisdiction to hear a murder trial and impanel a jury, but they can issue search warrants. They can find probable cause as to any offense. There's no limitation in this statute, OCGA 1510-2A1, about the level of offense. And, if the legislature had intended to include such a limitation, it would and could have included language to this effect into the statute. So the magistrate here was authorized to issue this warrant. Now, moving forward, beyond that, I believe the other issue that was sort of primarily raised where we had left off was the matter of the sort of geographical limitations. And that's going to be Division 2B, page 2 and 3 of Mr. Harvey's 8/28/2023 pleading, just to kind of direct your attention there. Now, it's claimed therein that the use of a search warrant to obtain cell phone records outside of Georgia makes the warrant fatally defective. It's not the case, Judge. Geographic limitation doesn't apply to search warrants for phone records. Georgia statutory law commands that, and this is again OCGA 1611-66.1C, and it commands as follows, that search warrants for production of stored wire or electronic communications and transactional records pertaining thereto shall have statewide application or application as provided by the laws of the United States when issued by a judge with jurisdiction over the offense under investigation and to which such records relate. This is the provision that's applicable here. As discussed just now, the judge who issued the search warrant had jurisdiction over this search warrant, despite that it was murder. This judge couldn't have heard, unless they were designated as a Superior Court judge, this judge couldn't have heard the trial of this murder. But they absolutely can make a probable cause determination as to the arrest or a search warrant relating to this charge. So the question now is, well, what about the laws of the United States? What do they apply and provide for here? Would the United States law permit this judge to issue the search warrant in question? Yes, the laws of the United States would. And I'll tell you this, the laws of the United States referenced in 1611-66-1 include the provisions of 18 U.S.C. Section 2701 and the stuff after, right, et sequitur. And that series of statutes addresses mandatory and voluntary disclosure of electronic communications records to the government, which is me. That's Registe v. State, R-E-G-I-S-T-E v. State. That's 292, Georgia, 154, Penn site 156. That's a 2012 decision. You can also refer, if you would like, to Hampton v. State, normal spelling. Another Supreme Court decision, 2014, 295, Georgia 665, 671 Penn site. And that's citing both Georgia and federal statutes. Anyway, one such provision that we're going to be looking at here is 18 U.S.C. Section 2703A. And pertinently, that provides as follows. A governmental entity may require the disclosure by a provider of electronic communication service of the contents of a wire or electronic communication pursuant to a warrant issued using the procedures described in the federal rules of criminal procedure, or in the case of a state court, as here, issued using state warrant procedures by a court of competent jurisdiction, which this court was. Federal Rule of Criminal Procedure, by the way, 41B, does create geographic limitations restricting search warrants to judges in the district where the search is to occur. That's correct. And often federal defendants raise this exact challenge that Nichols has raised here. However, when the federal courts of appeal address this issue, they have held consistently that Rule 41B does not apply to search warrants issued under 18 U.S.C. 2703. For instance, U.S. v. Ackies, A-C-K-I-E-S. That's 918 Federal 3rd, 190 at 194. That's a First Circuit 2019 decision. And there, it says the precise location information warrants obtained pursuant to 2703 for New York subscribers' phones were valid, even though issued by a federal magistrate in Maine. United States versus Burkos, B-E-R-K-O-S, 543 Federal 3rd, 392, Penn site 396-398, 7th Circuit, 2008. A magistrate for the Northern District of Illinois properly issued a search warrant for production of electronic records pursuant to 2703, even though it was directed at an out-of-district internet service provider located in not Illinois, but Texas. Finally, United States versus Bansal, B-A-N-S-A-L, 663 Federal 3rd, 634, Penn site 662, 3rd Circuit 2011, said that magistrate judges from Eastern District of Pennsylvania had the authority to issue warrants pursuant to 2703, even though they were ultimately executed upon internet search providers in California. So federal law permits a judge in one geographic jurisdiction to issue warrants for data under 2703 when that data is contained in a different geographic location. So Georgia's legislature, they authorized search warrants for electronic information with, quote, application as provided by the laws of the United States, right? And the laws of the United States provide a mechanism for judges to issue warrants for information outside of state lines, outside of the district. It is just that simple. And so we would ask that the motion be denied. I understand there's other grounds. My understanding is that maybe they've already been covered, but I'm happy to answer any questions or address those other grounds. But those are the two main sort of legal issues that, to my understanding, were before this court at this time.
I want to address the issue of Mr. Harvey raises on, this is page 3 of 8.
Sure.
In his particularized motion in 828. There's a failure to demonstrate probable cause. He's also indicated overbroad and non-particularized. He's also indicated failure to demonstrate required expertise or certification. And then I want to say on the 13th, I should say, I'm sorry, I apologize. Yeah, those are the other grounds I want to say is failure to demonstrate probable cause, overbroad and non-particularized, failure to demonstrate required expertise or certification.
All right, with the court's permission, I'll start with the probable cause. And Your Honor has already taken notice of what's in the affidavit, so we won't go through all that. I will remind the court of controlling law when it comes to magistrate's decision when it comes to probable cause. Let's go with Palmer v. State. That's 310 Georgia 668 672. And in there, it said, in reviewing whether probable cause exists to support issuance of a search warrant, we bear in mind the magistrate's task is simply to make a practical, common sense decision, whether given all the circumstances set forth in the affidavit before him, including the veracity and basis of knowledge of persons supplying hearsay information, there's a fair probability that contraband or evidence of a crime will be found in a particular place, in this case, a phone. The test is not a hyper-technical one, we all know this, right? But it's one to be employed based on the factual and practical considerations of everyday life. And I'll remind this court that a magistrate's decision to issue a search warrant based on a finding of probable cause is entitled to substantial deference by a reviewing court. And again, even in doubtful cases, the decision should be resolved in favor of upholding a magistrate's finding of probable cause. And here we look at the affidavit and we have as follows. We have an alleged shooting at a stoplight at the intersection of Windsor and Interstate 20. That's on March 14, 2022. There were two cars that pulled next to the alleged victim. The victim was shot. The two cars fled and went west on 20. Our affiant, Detective Hogan, was able to determine the driver of one of the vehicles and also the driver of another of the vehicles, which was the defendant in this matter. So there were arrest warrants for both of these drivers, including Nichols, and they were charged with, the charge at hand. They were both arrested, so Nichols is arrested, and only after that happens is his phone number subject to this warrant, and it was given to Detective Hogan, by Nichols in a post-arrest interview. And so the probable cause there, I think, speaks for itself, and if Your Honor's satisfied with that presentation, I'll move on to the next.
Yes, sir, you may move on.
All right, so the particularization, and I guess this is overbroad and non-particularized. It's absolutely particularized. It says exactly what they're looking for, and it also, of note, limits the search from March 14, 2022 to March 17, 2022. So that's the day after the incident up to the day, I guess, of or before Nichols' arrest. So it's not overbroad. It's extremely narrowly tailored. And I think the idea that it's non-particularized is...
What about his contention of his laundry list of data from the cellular provider, and he includes the subscriber information, cell site, historical precise location, available internet, and web browsing history, and all twinned or paired devices associated with this account?
But that's limited to a couple days. It's not like they're going on a fishing expedition for a long time. It's limited. And this is not an uncommon, quote, laundry list of things to look for when you have a warrant to search someone's phone that's, supported by probable cause. So this isn't anything beyond what you would normally see in this circumstance. This is, serious crime, and they have a phone number that they got from the, person that they're looking into. And so they want to go ahead and look. There's a fair probability there's going to be, evidence of a crime. So we want to look and see what, is there anything in there that's evidence of that crime? I disagree that it's overbroad, and I disagree that it's non-particularized. Just, Your Honor, and I'll say this. The idea that something is boilerplate, let's say, right, that sounds like it's the allegation here, because this is, boilerplate is not a criticism. Boilerplate language just means it applies in more than one circumstance. That's not a problem. That's a principle. That's good. Things that can apply to more than one circumstance are not inherently bad. So I disagree with that contention. I will move forward to the failure to demonstrate expertise, and this is kind of why I wanted to start with kind of reciting the affidavit. And I'm not going to get back into it, but it's right here in the four corners. Post-certified since '87, APD since 2011, Fayette County Sheriff's Department, Federal Air Marshals, DEA, homicide since 2017. Almost 2,000 hours of training. He's executed multiple search warrants pertaining to criminal investigations. And even if that wasn't in there, when it comes to the expertise and the certification, I don't see any case law here to say, well, what am I supposed to respond to? But I will say he doesn't need training about the use of cell phone records. He's just the person saying, hey, I got this phone number. I got this phone from this person who we've arrested for murder. We want to check the phone for evidence of same, okay? And Mr. Harvey or Ms. Westmoreland or whomever else is more than welcome to test that expertise on cross-examination. And they'll do a thorough and sifting job, I'm quite certain. And with that, and with the court's permission, I think I'll conclude unless there are any other questions.
No, sir, I don't have any other questions.
Thank you, Your Honor.
Harvey or Ms. Westmoreland or Mr. Garner?
I note that it's 5:45. If it gets too late, the rotten tomatoes will come flying from my colleagues. But let me start off where I think we left off last time. Number one, I think that we're all agreed that we're limited to the four corners of the affidavit. There's been no suggestion and no showing that there is anything presented to the issuing magistrate outside the four corners of the warrant. So we start with that basic principle, number one. And I'll get to that in a few minutes. We do know, and I started my challenge last time by saying that the judge that signed this warrant is not a Superior Court judge, but a magistrate court judge. That magistrate court judge does not have jurisdiction on the face of this warrant over murder cases. We know that. And the particular prevails over the general. A magistrate's court is not a court of general jurisdiction. We know that. And any suggestion otherwise is just flatly wrong. So let's start with the premise that Judge George is a magistrate judge. Magistrate judges do not have general jurisdiction, and they do not have jurisdiction over murder cases. So that then brings us to 16-11-66.1.
But they have jurisdiction to sign, do they have jurisdiction to sign warrants, search warrants?
They have jurisdiction to sign search warrants.
Even if that subject matter is homicide?
Yes, but they don't have jurisdiction over the criminal offense, not oversight.
I would agree with you that they cannot try a homicide case by jurisdiction, but they do have the ability to issue a warrant, a search warrant. And it may encompass something that they cannot try. It's the same thing. You go down to municipal court, it's the same thing that a municipal court judge, even though that is a jurisdictional issue, that court can handle a bind over for a particular case that they may not have a jurisdictional ability to try.
Right, because there's not a special statutory provision that changes that. And in this case, that's why I started with saying the particular prevails over the general. That's a well-known statutory provision. In OCGA 1611-66.1 is a particular statute that deals with the disclosure of stored wire or electronic communications in the records. So whether or not a magistrate has jurisdiction to handle, for example, prelims in a murder case does not give them jurisdiction over the criminal offense as denominated in 1611-66.1. That does not say jurisdiction over issuing search warrants. It says jurisdiction over the criminal offense under investigation and to which such records relate. That's 1611-66.1 subsection C. So applying that well-known principle that the specific statute controls over the general, 1611-66.1 prevails over the general statute, and Judge George did not and does not have jurisdiction over the criminal offense under investigation, which was, in this particular case, the offense of, and which is denominated in the warrant, 16-5-1. That's my first response. My second response is with regard to historical cell records, which is what this search warrant seeks to obtain. You know, there was a time when courts were asked to issue subpoenas under 2703. And Your Honor has been on the bench long enough to have had, I'm sure, countless investigators come to you and say, hey, I need a subpoena issued under 2703 for historical cell phone records. Well, and the request was made specifically under 2703, that particular act. We know that's not the case anymore. We know that's not the case because in Carpenter, in 2018, Carpenter, the United States Supreme Court said, individuals have a Fourth Amendment privacy right in historical cell phone records that can only be accessed under the Fourth Amendment by use of a search warrant. Okay, that's great. So instead of coming to a court with a 2703 request, you come with a search warrant. If we're operating under the four corners of this particular warrant, I invite the court to see if a request by the investigator or Detective Hogan was made pursuant to, give me these records, pursuant to 2703. No, it's not in there. The request was not made under 2703. It was not within the jurisdiction of the issuing magistrate, and it was directed to a T-Mobile law enforcement relations in Parsippany, New Jersey, not within the jurisdiction of anyone in the state of Georgia without obtaining a out-of-state warrant by going to New Jersey. It is a request that doesn't mention 2703. It's not obtained under 2703, even as an alternative, and therefore it fails both on its face jurisdictionally under those two provisions and under Carpenter versus the United States. That's number one. That's my first response. The second response, so we've talked about the jurisdiction, we've talked about the magistrate. Now let's talk about probable cause. I want to start by saying that while the affidavit describes Detective Hogan's history in working with, as a law enforcement officer, it contains not one word about his experience regarding the obtaining of cell phone records, the use of cell phones, and anything within his experience related to cell phones. Ordinarily, you would see in and I'm going to call it a boilerplate affidavit, you would see a detective saying, I know in my experience, after all this training that I've had, that criminals use cell phones, and that they use cell phones in committing their crimes, and therefore I want to search this cell phone. Well, we know that that is not enough. We know that boilerplate officer experience alone is not enough to justify a search warrant, and we know that because our Supreme Court has said that in Wilson versus the state at 315 Georgia 613. And in Wilson, they specifically said the generic use, criminals' use of cell phones too, if that's enough It's hard to imagine a case in which police cannot get that warrant. As Riley, and that's the U.S. Supreme Court case in Riley, reasoned in declining to apply the search incident to arrest exception to the warrant requirement, it would be a particularly inexperienced or unimaginative law enforcement officer who could not come up with several reasons to suppose evidence of just about any crime could be found on a cell phone. So the court, our Supreme Court in Wilson, specifically said that just saying, hey, he's got a cell phone is not enough. And you know why? Because the Fourth Amendment requires a nexus between the offense and a search of a particular item. That's what this issue is about. It's nexus. So let's look at the four corners of this affidavit. There was a car. There was a car that pulled up alongside another car. Someone was shot. According to the affidavit, Mr. Nichols was driving one of the vehicles. An arrest warrant for Mr. Jackson and Mr. Nichols was obtained. And Mr. Nichols was asked a question, what is your phone number? And he provided his phone number. Was he asked, did you have that phone with you? Did you have that phone with you that night, Mr. Nichols? Did you use that phone that night, Mr. Nichols? Did you call Mr. Jackson? Did you call Mr. Farley? Did you call anybody on that phone, Mr. Nichols? No. And is that in the affidavit? No. Is there a single line in here that says, boy, I know that Mr. Nichols used his phone that night. I know that all these folks were talking to each other last night. Or I believe that that's the case. So I want to look at his records. The phone number that is the subject of this warrant was given to me by Mr. Nichols in his post-arrest interview as belonging to him. Not that it was used, not that we think it's used, not that in my experience it's always used. That will be obtained, and the information that will be obtained will be used to determine who was communicating with, who he was communicating with, his top callers, and his location at the time of the murder. So where's the nexus to the use of the phone? There is none. There is none. And even if Detective Hogan said, boy, I know that these guys used their phones, which he didn't. There is still no nexus. And let me refer you to Landers versus the state at 355 Georgia Appeal 69. And Landers reaffirms the four corners rule and specifically says that suspicion or strong reason to suspect that something may have happened, or the use of a phone, and this is an electronic search like the state wants to do here, is not probable cause because there is no nexus, that we need more than suspicions or conclusions, some connection other than that. The Landers court cited Brown at 267 Georgia, 820 at 832. That was an automobile search. But Landers was the search of an electronic storage device. And that's precisely what is being asked to be looked at in this particular case. But there's no nexus. Nothing in the four corners of this affidavit suggests that any phone was used by any participant that evening, and there is therefore no no nexus. Now, what did we ask for? All subscriber information, that's fine. Social security number, activation date, address, account features, cell site locations and sectors for all outgoing and incoming voice, SMS, MS, MMS, and date transactions, all available historical precision location NELOS reports, all available internet and web browsing history, to include history with and without location information. Internet and web browsing history, where's the probable cause for that? Each item, it is a basic fundamental principle of Fourth Amendment law that each item requested requires its own probable cause and nexus. And when the state says, boy, there's nothing wrong with boilerplate, there is everything constitutionally wrong with boilerplate. For the time frame, this will result in the successful identification of telephone numbers with which persons communicated most frequently. I don't know whether it'll be successful identification, and I don't even know what that has to do with the probable cause underlying this application. The general geographic area, the person's frequented most. This is precisely the privacy interest that Carpenter said to everybody in the United States, that cell phones are so ubiquitous, you need Fourth Amendment protections. And we're going to give you those Fourth Amendment protections. So this is unconstitutional, overbroad, unparticularized, a Fourth Amendment
Thank y'all for joining our broadcast from court today. This is the broadcast of Dana J and the Dream Team. I see all y'all. Thank y'all for joining. We'll be back tomorrow. Y'all have a good day. And don't forget, Dream Team will be live later on at 8 o'clock. Y'all be blessed. Good night.
Say you love it, what you gonna do now? Hope you're ready, cause I'm really about to put it down. Girl, you know that I will never disrespect. touchdown, gotta make